Okay, good day again, class. Welcome to Criminal Law, Book 1. Okay, this is part 2 of my recorded video lecture. So, we'll tackle Act number 3815, the revised Penal Code as amended. Okay, Act number 3815 is an act revising the Penal Code, the revised Penal Code, and other penal laws. So, Article 1. So, time when the revised Penal Code takes effect. So, under Article 1, this code, the revised penal code, shall take effect on the first day of January 1932. So January 1, 1932. Question. Okay. What is the effectivity date of the revised penal code? So the answer is January 1, 1932. Second question. Uh, when was the revised penal code passed into law? So the answer is December 8, 1930. Okay? So if you will be asked as to the date of effectivity of the revised penal code, you answer January 1, 1932. When the passage into law of the revised penal code, that's December 8, 1930. Okay, take note of that. So the revised penal code consists of two books. Number 1 is Book 1, RPC Book 1, and second is RPC Book 2, Revised Penal Code Book 2. So in the first semester, okay, we will be focusing on Book 1. And Book 1 consists of two parts. Number 1 is the basic principles affecting criminal liability. Okay? So that's from Articles 1 to 20. While the second one, the provisions on penalties, including criminal and civil liabilities, that's Articles 21 to 113. And, okay, God willing, if you'll be able to pass my subject, okay, in the second semester, we'll be focusing on Book 2. Okay, Book 2 defines felonies, like what is theft, what is robbery, what is homicide, okay, with corresponding penalties, whether it's arresto minor, arresto mayor, prisión correccional, prisión mayor, reclusion temporal, or reclusion perpetua. And also in Book 2, the felonies there are classified in group under 14 different titles. That's why we have crimes against persons. What are crimes against persons? We have parricide, murder, rape, homicide, infanticide, etc. Crimes against properties. We have theft, qualified theft, robberies. Okay, robbery with violence against or intimidation against persons, or robbery with the use of force. Okay, so that's from Articles 114 to Article 365. So the scope of Book 1 is from Articles 1 to 113, while the scope of Book 2 is from Articles 114 to 365. Okay? So Article 2, application of its provision. So except as provided in the treaties, okay, like the military basis agreement and the laws of preferential application, like a congressman who is immune, okay, a congressman or senator who is immune from suit, or is immune from libel, slander, okay, while in regular or special session, okay, the provision of this code shall be enforced not only within the Philippine archipelago, including its atmosphere, its interior waters, and maritime zone, but also what? Outside of its jurisdiction. So this is the exemption of the general rule of the territoriality characteristic of criminal law. Why? Because, di ba, as a general rule, under the territoriality principle of criminal law, the revised penal code or penal laws are enforceable only within the Philippine territory, within the Philippine archipelago, including its atmosphere, interior waters, and the maritime zone. And this Article 2 is the exception. So the revised penal code, okay, can what? Take effect outside, okay, of the Philippines against those who should commit an offense while on a Philippine ship or airship. Okay? So if you will commit a crime inside a Philippine ship or a Philippine airplane, either PAL or Cebu Pac or AirAsia, okay? I don't know if AirAsia is of Philippine registry, or it is registered in the Philippine Bureau of Customs, but let's just say, or let's just assume that it's a Philippine registry, then we will assume jurisdiction. Why? Because the revised penal code can have jurisdiction over you because it falls under the exemption because you committed a crime while inside a Philippine airship. And then should forge or counterfeit any coin or currency note of the Philippine Islands or obligations and securities issued by the government of the Philippine Islands. So if you are abroad, okay, and you counterfeit our bills, okay, here in the Philippines, oh, you can be held liable under Philippine criminal law. And then if you will introduce number 3, such currency note, okay, or obligations and securities, you import those in here in the Philippines, you can be held liable under our Philippine criminal laws because it falls under the exception number 3, should be liable for acts connected with introduction into these islands of the obligations and securities mentioned in the preceding number. Okay, that's number 2. And number 4, while being public officers, if you are an ambassador, okay, in another country, you are a Philippine ambassador, and then you will commit an offense in the exercise of your functions, you will commit direct bribery, etc. Okay, Philippine criminal law will have jurisdiction over you. And last number, if you will commit a crime, okay, outside the Philippines, that is against national security, like treason, okay, and the law of nations, okay, defined in Title 1 of Book 2 of this code, you can be held liable, okay? So, extraterritorial application. You should memorize this. There are 5 instances where the revised penal code shall take effect outside the Philippine territory. General rule, the revised penal code shall take effect only within the Philippine territory. Exception, if it is what? Committed outside the Philippines and they commit the offense while on a Philippine ship or airship. So let's just say, na-commit kag crime inside a PAL airline while in flight. Okay? PAL airplane rather. Okay? Nangawat ka sa imong co-passenger. Okay? Or what? You punch your co-passenger. Okay? That's serious physical injuries. Nangawat ka, that's theft. Okay? Na kay gibully dito, na kay gikuan, na kay gisampalong. Oh, etc. Okay? So, Philippine courts will have jurisdiction over you. Why? Because you committed a crime while inside a Philippine ship or airship. Okay? And any person who committed a crime on board a Philippine ship or airship while the same is outside the Philippine territory can be tried before our courts for violating the revised penal code. But when, okay, take note of this, when the Philippine vessel or aircraft is in the territory of a foreign country, okay, let's just say inside na sa territory of the United States of America or in Canada, the crime committed on said vessel or aircraft is subject to the laws of that foreign country. Okay, this is the exception. If naa na gani ang Philippine ship or airship sa foreign country, okay, it is subjected na to the laws of that foreign country, not of the Philippines. So, a Philippine vessel, take note, or aircraft must be understood as that which is registered. Dapat registered siya sa Philippine Bureau of Customs. Question, when is it a Philippine ship or airship? So, if it is registered in the Philippines and under Philippine laws. So, even if totally or wholly owned by a Filipino citizen, if it is not registered in the Philippines, it cannot be considered as a Philippine ship or airship. Why? Because it is only upon registration that this aircraft or vessel can fly to the Philippine flag. Therefore, it is the registration which is the operative act which makes it a Philippine ship or airship. Okay? So, This is a situation where a crime is committed on board a Philippine vessel while outside the Philippine territory but not in the territory of another country. Because if it is in the territory of another country, o kani exception, okay, it is the laws of that foreign country that will take in effect. Okay? So, question. If a Philippine vessel is on waters of the Philippines, okay, and a crime was committed on board, what country will have jurisdiction? Of course, it is the Philippines. Okay? And what if that Philippine vessel is on the high seas or international waters and a crime was committed on board the said Philippine vessel? What country will have jurisdiction? Still the Philippines because of the extraterritorial application of the RPC. So even if outside na siya sa Philippines, okay, naman tayo gitawag nga extraterritorial application. So it is a situation referred to as the first circumstance under paragraph 1 of Article 2. It is a situation where the Philippine ship is outside the Philippine territory, but not, again, but not in the territory of another country. Okay, second instance. So those who forge or counterfeit any coin or currency note of the Philippines. Okay, so example, Mr. X was in Japan. He counterfeited Philippine coins, okay, or bills. He then introduced these coins into the Philippine Islands. Although the crime has been committed in Japan, can he be held liable here in the Philippines? Definitely, the answer is yes, he can be held liable before the Philippine courts. This is necessary. Okay? Nga naman siyang i-punish because this is necessary in order to maintain and preserve the financial circulation and financial stability of the Philippines. Otherwise, no country would be interested in prosecuting him except the Philippines. Because ang iyang gipigay nga kwarta is Philippine coins or Philippine money. Okay? Because it is only the Philippines that will be affected by said counterfeiting of coins. That is why. Okay? If ever mag-counterfeit ka coins or currency note, okay, mga paper bills belong to the Philippines, even if you are outside the country, maybe let's say you're in the US, you're in Japan, Philippine laws, okay, will have jurisdiction over you. Okay? Philippine courts will have jurisdiction over you. Why? Because okay, this is in order to maintain and preserve the financial circulation and financial stability of the Philippines. Okay? No country, okay, would be interested in prosecuting that person who counterfeited our coins or Philippine money. Okay? It is only the Philippines that will be affected by such counterfeiting of coins. Therefore, they can be under our Philippine courts. Okay? We will have jurisdiction over that person. So any person who makes false or counterfeit coins or forges treasury or banknotes or other obligations or security, this is one under Article 166, Book 2, in a foreign country, may be prosecuted before our civil courts for violation of Articles 163 or Articles 166 of the Revised Penal Code. Don't worry, we will be discussing this. If ever, okay, you will pass Book 1. Okay? Nani siya sa Book 2, Articles 163 to Article 166. Third, those who should be liable for acts connected with the introduction into these islands of the obligations and securities mentioned in the preceding number. Preceding number meaning number 2. So what's the reason for this provision? Okay, is that the introduction of forged or counterfeited obligations and securities into the Philippines is what is as dangerous as the forging or counterfeiting of the same. Okay, it will be detrimental to the economical interest of our country. Therefore, we will still have jurisdiction over those persons who will what? Introduce into these islands the obligations and securities mentioned in the preceding number. So fourth, those who, while being public officers or employees, should commit an offense in the exercise of their functions. So this refers to public officers who are working in another country while they are working, they committed a crime in the exercise of their function. And if the crime they commit, okay, is not connected with the exercise of their functions, then they should be prosecuted in the courts of the country where they are assigned. So take note that the crime they must commit, okay, in order to be held liable under Philippine laws, must be a crime committed in the exercise of their functions. Because if not in the exercise of their functions, then they should be prosecuted in the courts of the country where they are assigned. Okay? So, the crimes that may be committed in the exercise of public functions are, okay, take note, direct bribery under Article 210, indirect bribery under Article 211, then frauds against public treasury, 213, then possession of prohibited interest, Article 216, and malversation of public funds or property, 217, or failure of accountable officer to render accounts, that's Article 218. Then illegal use of public funds or property, that's Article 220. And failure to make delivery of public funds or property, Article 221. And falsification by a public officer or employee committed with the abuse of his official position, that's Article 171. So when any of these felonies is committed abroad by any public officer or employee while in the exercise of his functions, he can be prosecuted here in the Philippines. And last number, the fifth instance. So those who should commit any of the crimes against the national security and the law of nations. Okay, this is defined in Title 1 of Book 2 of the Revised Penal Code. So what are crimes against national security? So natin ito nga treason. You betray your own country during war. Okay? Then conspiracy and proposal to commit treason. Misprision of treason. Espionage, inciting to war or giving motives for reprisals, violation of neutrality, correspondence with hostile country, and flight to enemy's country. And if any of this crime is committed, even if it is done outside the Philippine archipelago, maski na siya sa US, okay, sa Japan, sa China, the offender can be prosecuted before the Philippine courts. Crime committed against the law of nations include the following: piracy, katong Captain Phillips nga movie, piracy, qualified piracy and mutiny. Okay? So, if the crime committed is against the law of nations, said offender can also be prosecuted before the Philippine courts, even if committed outside the Philippine territory. So, you should take note of that. So, Article 3. So, what are felonies? So, under Article 3, they are what? Acts or omissions punishable by law. What are acts? Acts are the external body movement tending to produce an effect to the external world. What's an overt act? What's an overt act? It is an act that is directly connected with the offense being committed. The act of what? Stabbing a person. The act of pointing a gun at another person. The act of opening the vault. The act of opening the gate. Okay? That's an overt act of what? The act of opening the gate is an overt act of trespass to dwelling. The act of stabbing a person, that's an overt act of what? Killing a person. Murder. Okay? Omission, it is the failure to perform a positive duty required by law. Katong example na ko about lost and found property. So if you found a lost property, you are required by law to turn over such lost property to the rightful owner or to the local authorities. Otherwise, if you do not do that, you can be held liable, okay, for the crime of theft. Okay? So that's one good example of omission. And also, if you abandon persons in danger, or if you abandon your victim, let's just say nakaligis ka, then you will abandon your victim. Uy, that's an aggravating circumstance. Okay, so mo aggravate imong penalty, musta ka. So you should help your victim. Otherwise, abandonment of one's own victim ka. Okay, and law. By law, punishable by law. What is a law? Again, law is a rule of conduct, just, obligatory, promulgated by a legitimate authority, and of common observance and benefit. So felonies are committed not only by means of deceit or dolo, but also by means of fault or culpa. Take note, it is committed by means of deceit or dolo or by means of fault or culpa. What do you mean by deceit? So there is deceit, okay, when the act is performed with what? Deliberate intent. There is deliberate intent to kill, deliberate intent to steal, etc. And there is fault or culpa when the wrongful act results in what? Imprudence, negligence, lack of foresight, or lack of skill. So, what are felonies? So, felonies are acts or omissions punishable by the revised penal code. And what are the elements of felonies? So, there must be an act or an omission. And such act or omission must be what? Punishable by the revised penal code. And what? That the act is performed or the omission incurred is by means of dolo. Dolo meaning there is deliberate intent to commit a crime. And there is culpa when there is nadri, fault, when the wrongful act results in imprudence, negligence, lack of foresight, or lack of skill. So what are acts? So acts refer to any body movement which has a direct connection to the felony intended to be committed. So this is overt acts. Okay? It has a direct connection to the felony intended to be committed. So, let's just say you want to kill a person. Kung sa may overt act ana, the act of stabbing, the act of pointing a gun and shooting the person. Muna siya overt acts. Okay? So, an act is what? There are two kinds of acts. Number one is external act. So, external act meaning there is an overt act in connection with the felony intended to be committed. And then internal acts are what? Mere criminal thoughts. Okay? Imrang gihuna-huna. Okay? But kana im gihuna will never give rise to a crime. Why? Because the law requires an act. Okay? Na dapat naa kay buhaton. But if imo ra gihuna nang rape, ganan ka, naibog ka ng bayi na imo ganang ripon or kidnapon, okay? You are not liable. Why? Because mere criminal thoughts only ramana. Okay? It will never give rise to a crime. It will give rise to a crime when naanay overt acts or imo na nakommit ang crime. Okay? Example, A lust for his neighbor. Okay? Whenever the neighbor would pass by going to work, he would always look at the neighbor. And for the whole day, he would think of the neighbor with nothing but lust. No matter how criminal his thoughts are, it will never give rise to a crime because it is merely what? An internal act. Unless he performs an external act or an overt act related to the acts of lasciviousness or attempted rape, okay, the law, again, the law requires an act. Dapat na agad kay acts. Okay? Otherwise, no liability, no criminal liability. Omission. So, what is an omission? Omission is the failure to perform, okay, a duty which is required by law. What's an example of an omission? So, okay, unang ibalik. If a person found any personal property on the street or any place and he failed to deliver the same to the owner or to the local authorities under Article 308, he becomes liable for theft. Why? Because you are required by law to turn over such personal property to the rightful owner or to the local authorities. Or if a person, okay, was driving his vehicle, then he bumped and hit another person, and instead of helping that person, okay, he left. So this is a hit and run situation case. So because he failed to lend help and assistance to that victim, it will what? Aggravate his criminal liability under Article 365. And that's what you call abandonment of one's own victim. So here, for failing to perform an act which is required by law to be done, he commits what? A felony. Why? Because what is a felony? It is an act or omission. Okay, that is punishable under the revised penal code. So felonies are acts or omissions punishable by the RPC. What's RPC? Revised Penal Code. So there are two kinds of felonies. What are the two kinds of felonies? We have deceit or dolo and then fault or culpa. What do you mean by deceit? Deceit or intentional felony exists when the act is done with deliberate intent. Okay, intent to kill. Okay, voluntary ang act. Okay? So an intentional felony is a voluntary act. Pinaka-free will. Okay? Voluntary. Wala nagpugos nimo. Okay? Because it is committed what? By means of deliberate intent. Like ganan ka mo patay tao, imong gipatay. Okay? That's what? There's deliberate intent because you shot that person voluntarily. Wala nag-force nimo to shoot that person. Okay? So fault or culpa. Fault or culpable felony. Okay? Fault or culpa is otherwise known as culpable felony. Deceit or dolo is otherwise known as intentional felony. Okay? So fault or culpa. Fault or culpa exists when the wrongful act results from what? Imprudence, negligence, lack of foresight, or lack of skill. So under Article 365, a culpable felony is defined as one wherein the offender, although without malice or deliberate intent, and no deliberate intent, but caused an injury to another by means of what? Negligence or imprudence. Therefore, even a culpable felony is a voluntary act. Okay? So what are examples of fault or culpa? Kanang mag-overspeeding ka. You're driving your motorcycle or your vehicle, nag-overspeed, and then makaligis kang tao. Okay? That's imprudence. Okay, nag-overspeeding ka. You know nga, dagang pedestrians nga mong labang, but, oy, kusugi kang padalagan. Okay? That's reckless imprudence. Okay? Reckless imprudence resulting to what? Resulting to homicide. Okay, if namatay. Or if makakause injuries, reckless imprudence resulting to serious physical injuries, less serious or slight physical injuries. If na property na damage, so that's reckless imprudence resulting to damage to properties. Okay? So if ever, okay, let's just say you lived sa second floor, okay? And then nagbutang ka og pot, okay, sa balcony ninyo. And wala damha na nilakaw. Okay, tungod sa imong balcony. Dahil may kusog hangin, nahulog flower pot. Naigo sa ulo. Ang victim, namatay. So na kay negligence. Okay? There is what? Lack of foresight as to what will happen. You can be held liable. Or if, naka sa third floor, okay, tungod kay kasabaan ka, imong professor, gidalagan ka pagawas, then, ano mo ang usa ka student, nahulog sa third floor. You can be held liable. Why? Because that's negligence. Okay? So you should be careful. Okay? You should be what? Prudent enough to know na basig maka-cause ka og injury to another. Otherwise, you'll be held liable for reckless imprudence. Yeah? Intent. What is intent? Intent is the use of a particular means to achieve the desired result. Can you see intent? Of course, no. Why? Because it is an internal state of mind. And we have here factors to determine intent. So we have number one, the means used by the malefactors. Second, the nature, location, and number of wounds sustained by the victim. Number three, the conduct of the male factors before, during, or immediately after the killing of the victim. And number 4, the circumstances under which the crime was committed and the motives of the accused. So you should take note of this. You should familiarize the factors to determine intent. Okay, let's apply those factors here in this example. So A was walking. Then here comes B with a lead pipe and hit the head of A with it. B hit it hard and thereafter ran away. A went to the hospital. However, based on the the medical certificate, no injury whatsoever was sustained by the head of A. So there was no injury. Nevertheless, A filed a case for attempted homicide against B. Therefore, intent to kill is incumbent to be proven by the prosecution because the case filed is attempted homicide. Now question, will B be held liable for attempted homicide? Was there intent to kill? The answer is no. There was no intent to kill. Why? Let us apply, in this case, the factors to determine whether intent is present. In the example given, there was no intent to kill. Okay? Second question, was there motive? The answer is no. There was no motive. What was the nature and number of weapons used? He used what? A lead pipe. Okay? And he hit only the victim once. Okay? What is the nature, number, and location of the wound? The victim did not sustain what? Any wound, despite the fact that it was hit and with a lead pipe. What was the manner of committing the crime? After hitting A once, B ran away. If he had intended to kill, if there's intent to kill the victim, he would hit A several times. But in the example given, kasara niyang igo sa ulo. So there's no intent to kill. Okay? And what were the act, deeds, and words made by the offender before, during, or after the commission of the crime? Wala man siya ingon nga ganahan niyang pat yun, like before committing the crime. Ganahan akong pat yun si A. Or after committing the crime, ingon siya, yes, successful, napatay na ko si A. Oh, wala. He just saw the victim and then hit the victim. After hitting the victim, nidalagan siya. And all of these would show that there was no intent to kill on the part of the said offender. Therefore, B should not be convicted of attempted homicide, but for physical injuries only. Either slight, less serious, or serious, depending, okay? Depends on the case. So, example, the use of a lethal weapon would show intent to kill on the part of the offender, although death did not arise. And taking of personal property of another without consent of the owner would show intent to gain. Okay, take note of that. If mo gamit na gani kag lethal weapon, such as a gun or a knife, okay, nananday presumption nga intent to kill. Okay? Even if wala namatay. So, pwede na siya mahimong attempted or frustrated case of homicide or murder. While in the case of personal property, in case of theft, okay, once imo on personal property sa katawo that is not yours, automatic. Okay, it will show intent to gain, naka-intent to gain. Why? Because in the crime of theft, there should always be intent to gain. And in the crime of murder, there should always be intent to kill. Okay? Just take note of that. Okay? Intent to kill must be proven in frustrated or attempted homicide cases. Example, A and B were fighting. A was losing and so A shot B. B was hit on the left arm. He was brought to the hospital. Thereafter, after B's release from the hospital, he filed a case against A for attempted homicide case. Since the case filed is attempted homicide, the prosecution has the burden of proving intent to kill, okay, on the part of A when he shot B and hit him on the left arm. Why? Because if the prosecution will not prove, okay, or fails to prove intent to kill, okay, it will downgrade the crime filed from attempted homicide to physical injuries. Okay? So otherwise, if the prosecution failed to prove intent to kill on the part of A, then A can only be convicted of serious, less serious, or slight physical injuries, depending on the date required for medical intervention. Or what? Should be acquitted of the crime. Okay? Always remember, pag attempted na gani, okay, dapat you must prove intent to kill. Okay, but what if in the course of their fight A was losing, and so A took out his pistol and he shot B. B was shot on the heart. He was hurt. A fatal wound or a mortal wound was sustained because it was his vital organ which was hit. A immediately brought B to the hospital. However, upon arrival, he was pronounced dead. Therefore, the heirs of B filed a case for homicide against A. His defense, I have no intention to kill B, according to him. He only intended to threaten B because they were fighting. Now, will A's defense stand before the court? The answer is no. Why? A's defense that he has no intent to kill B will not lie. The reason is the victim died. Therefore, intent to kill becomes a what? A general criminal intent. And general criminal intent is presumed by law. Okay? So the prosecution need not prove intent to kill. Okay? In homicide, parricide, murder, infanticide. Because namatay naman ang victim. Ang prosecution mo prove ra og intent to kill when wala namatay ang victim or when attempted lang. Attempted homicide or attempted murder. Why? Why need i-prove? Kaya if dili i-prove, okay, sa mga attempted cases, pwede ma-downgrade ang crime to what? Physical injuries or pwede ma-acquit si accused. Okay? So it is only in the attempted and frustrated stages, okay, wherein intent to kill is considered an element. If consummated na ang crime, like namatay na yun, no need to prove intent to kill. So why is it only in the consummated stage of homicide, parricide, this is parricide, murder, infanticide, and intent to kill is presumed? Because the best evidence to prove intent to kill is the body of the victim. The victim died. Therefore, it's a general criminal intent and it is presumed by law. So, is there a defense to negate criminal intent? Na ba? O, pwede, yes. If the accused may plead mistake of fact. Okay? Later, we'll discuss mistake of fact. So, we have two kinds of intent. Number one, general criminal intent and specific criminal intent. So always remember that general criminal intent is conclusively presumed by law by the mere doing of the act. And the prosecution does not have the burden to prove it. So some example of general criminal intent. Namatay si victim. In a murder case, namatay si victim. For specific criminal intent, it's just like an element or an ingredient of the commission of the crime. Okay, therefore, it must be proven by the prosecution beyond reasonable doubt. So here, in attempted or frustrated cases of homicide or murder, the prosecution needs to prove intent to kill. Otherwise, if they will fail to prove intent to kill, then the proper charge should be physical injuries only, either less serious, slight, or serious physical injuries. Okay. So, in specific criminal intent, it is what? It is an element or an ingredient of the crime. Okay? So, if ma-prove ni prosecution nga there's intent to kill, okay, automatic homicide, attempted, or persuaded homicide. But if they will fail to prove, okay, intent to kill, physical injuries only. Okay, what is motive? Motive is the moving power which impels a person to do an act to achieve the desired result. Usang motibo ba? Motibo. Gipatay ni mo sa tao because naglagot ka. Okay, muna siya. Naglagot ka. Motive. It's your moving power. Kailangan po, ipapatay ka tao, wala ka galagot. So motive is the moving power which impels a person to do an act to achieve the desired result. And how do you prove motive? Okay, muna siya. By testimony sa mga witnesses. as to the acts or statements made by the accused before or immediately after the commission of the crime. For example, very good. Before the killing of a witness saw B threatening to kill A. So therefore, B would have the motive because of his acts prior to the commission of the crime. O, diba? Before the commission of the crime. Or after the killing, muna nagpatay. Nanapoy witness nga nakakita ni B nga ni-run away from the scene of the crime and laughing, saying, "Finally, I have my revenge." So nanay motive. So here, motive is established by the acts or statements made by the accused prior to or after the commission of the crime, but not during. Okay, because in motive, there is no what? Direct evidence. So the witness did not see how the crime was committed. Okay? So mistake of fact. What do you mean by mistake of fact? So it is the misapprehension of facts on the person who caused injury to another. So if a person acted under mistake of fact, can he be absolved of any criminal liability? The answer is yes, because he acted without criminal intent. That is, had the facts been as he believed them to be, his acts done would have been lawful and justifiable. Okay? So, elements of mistake of fact. So, before one may be absolved of criminal liability for having acted under mistake of fact, the following are the elements. The act done would have been lawful, okay, and justifiable had the facts been what the accused believed them to be. Had it been as he believed, the act performed would amounted to justifying or exempting circumstance. Justifying meaning maybe the accused acted in self-defense. Okay? He thought nga threat ang usa ka tawo, but later on he found out nga dili day threat, nag-joke ra di ay do napatay niya. Okay? So there's mistake of fact. Had the act done have been lawful and justifiable, had the facts been what the accused believed them to be, had it been as he believed, the act performed would have amounted to justifying or exempting circumstance. Because if you will kill a person by virtue of self-defense, you will not have criminal liability. You will be absolved from any criminal liability because you acted through self-defense. Second, that the intention of the accused in doing the act must be lawful. Dapat must be ignited by a noble or lawful or justifiable intent. No criminal intent. Dapat lawful. Dapat he must act with self-defense. Okay? That the mistake of fact be without fault, negligence, careless on the part of the offender. Okay? Dapat ulit negligence or carelessness on the part of the offender. And take note that the offender can be negligent in ascertaining the true facts of the case and at the same time invoke mistake of fact. So one good example is the case of Achong, US versus Achong. So one day, okay, at night, okay, one evening, he was sleeping, okay, and then nakamata siya nga naay nagtuktok sa iyang room. Then ni gawa siya. Ingon siya nga, kinsa na? Wala man ito bag. Sig tuktok. Nakuyawan si Atsyong. He thought that kawatan or bad elements. Okay? So, nikuha siya kutsilyo. Iyang gibutangag lock ang door. Iyang gibutangan og kasi tawag ani, chair. Pag ana, sige naman mong gatuktok. Then nilagpot ang chair. Nakuyawan siya. So, iyang gidunggab. O kinsa tong misulot. Not knowing that it was his roommate. Okay? He thought nga need niya i-defend himself by virtue of self-defense because he may be killed by the the would-be aggressor. Okay? But knowing nga iya rin itong roommate, nag-prank ka rin niya. So he was charged. But he was absolved of criminal liability because he invoked mistake of fact. Why? Because he committed a lawful and justifiable act. Okay? had it been as he believed, the act performed would have amounted to a justifying circumstance. Kay if natinuod to nga bad element, uy, justifying circumstance na yun. So, and the intention of the accused in doing the act is lawful. Lawful mo ito yung ibuhat. Hadlok siya. Una ay nisulod sa iyang property. Okay, and he acted without negligence. Why? Nangutan naman siya. Kinsa na. Wala man kayo nitubag. Nag-prank na di ay. Oh, so wala siya fault. Wala siya negligence at all. Therefore, he invoked mistake of fact and he was absolved of any criminal liability. Now, can a crime be committed without criminal intent? Yes, of course. Number one, by culpable felony. Katong mga when the act results in imprudence, negligence, lack of foresight, or lack of skill. And, of course, violation of special penal laws. Mga acts mala prohibita. Okay? So what are acts mala prohibita? These are acts which are only wrong because there is what? A law that prohibits and penalizes it. So they are not inherently wrong. So may example ani, mga illegal possession of unlicensed firearms. Again, acts mala prohibita are only wrong because there is a law that prohibits and penalizes it. While acts mala inse, inherently, these are acts that are inherently evil. Yung mga rape, mga pagpatay, killing, okay, or stealing. So these are acts malainse. Acts malainse, again, these are acts which are inherently evil or wrong per se. Even if there's no law punishing it, it is considered evil. While acts mala prohibita, they are only wrong because there is what? A law that prohibits and penalizes it. Okay. So, always remember, of course, not all acts punishable by special penal laws are mala prohibita. At exceptions. So, there are some special penal laws which punish acts mala inse, like plunder. Okay? According to the Supreme Court, plunder is mala inse or malam inse because criminal intent matters. So, take note that not all acts punishable by special penal laws are mala prohibita. Na exceptions na, like plunder, which is a special penal law, yet the SC or the Supreme Court said that plunder is mala inse. Okay, so criminal intent matters, okay, for mala inse crimes. Okay, so that would be all. Thank you. Please stay tuned for part 3 of my recorded video lecture. Thank you very much for listening. God bless.